All right, Evan, you are clear to proceed.
All righty, let's start with the State Ethics in Government Act. And I need to advise all members of this subcommittee that it's the duty of members to avoid conflicts of interest and appearances of conflicts of interest, and are instructed to refrain from anything where there is a conflict or an appearance of a conflict. Does anybody start? Hearing none, we'll begin. We don't have any minutes to approve, other than quite the discussion in front of the full ethics committee that was deep and wide-ranging and very instructive. So what the full ethics committee asked us to do is reconvene, and sort of like the Allen charge for those of us that do jury work, that say go back into the jury room and come to some conclusion, and don't come out until you have some resolution of this matter. Because as we presented to the full ethics committee, the subcommittee was split evenly about how to proceed on Rule 1.6. But as the full ethics committee discussed this issue, and as we considered once again all of the blizzard of comments that we've received from practicing lawyers around the state, it was worthwhile to come back together and see if we could find some solutions to the complex issues that this particular inquiry presented. So I think that Suzanne and Brian have very ably put together some possible solutions that include, I hope everybody got it, that would be a new comment to Rule 1.6. And this is an issue meeting about whether or not Rule 1.6 prohibits lawyers from using prior legal research or legal knowledge acquired in a past representation. So I think let's start, Brian and Suzanne, if you guys are okay with that, with discussing the possible new comment to Rule 1.6, and see if there's any discussion or any wordsmithing or any additions or modifications that need to be talked about on this proposed new comment. Is that a fair place to start, guys?
I think that's a great place to start, and I will I'll take the lead on this one, because this is all my fault. I had a bit of after we talked in October, then I had a moment where I just started trying to process everything that everyone had offered at the meeting, which was a great discussion, and just try to put some of these thoughts onto paper. And so to kind of set us up, as Suzanne had sent out the kind of proposed amendments we're going to discuss, and I actually have some additional tweaks that I'm going to I guess offer to you all today just to consider. But I was really trying to separate out the two things that we are talking about. It seems like we're talking about, we have been talking about legal research and legal knowledge. That really isn't encompassed by the prohibition that we see in 1.6, this requirement to keep confidential the information that we acquired during the representation. It seemed like everybody was on the same page that when we're talking about legal research, legal knowledge that you acquire during the representation of a client is not something that you have to keep hidden, locked in your vault, and cannot use subsequently for the benefit of a next client and so forth. And so we tried to address that first part with the comment to 1.6 that was sent out. I'm going to go ahead and share my screen so we can all be on the same page. And you're going to see that I've added some language here to the introductory kind of label, just to clarify exactly what we're talking about, what's the goal of this particular proposal. So again, the first one being this new comment to Rule 1.6 that is supposed to address this question or the issue that we run into, to really clarify that 1.6 does not encompass legal research and legal knowledge. So you see the language here in front of you. In fact, let me go ahead and just zoom in a little bit more in case anyone's on a smaller screen, so we can all be looking at the same thing. But this comment just says the term information acquired during the representation, of course, that language taken directly from Rule 1.6. The term information acquired during the representation is intentionally broad to ensure client trust in the lawyer's duty to maintain confidentiality of all information learned about or relevant to the client during the course of the representation, whatever its source. This broad assurance of confidentiality enables full and candid disclosures between client and lawyer for the benefit of client's interest in pursuing the representation. However, the term does not encompass information acquired through legal research or other expansion of the lawyer's legal knowledge, even if acquired during the representation, as the client does not have any reasonable expectation of confidentiality of such information. So, again, this is just kind of looking at it a little bit more in depth. The first part is really an attempt to kind of set the stage that, yes, confidentiality, as broad as it is in 1.6, as we have discussed over and over in this subcommittee, it's intentionally broad. It's supposed to ensure trust between the client, or really on the client's part, in being able to disclose the specifics of their particular case and their experience to their lawyer as they seek the legal services that they've retained the lawyer for. So some of the language is pulled from other comments, specifically the reference to, all of the stuff that we get, whatever its source, is supposed to remain confidential. But then that last sentence kind of carving out and clarifying that the information that you gather as you prepare for a client's case, as you learn perhaps not necessarily learn a new area of law, but you do your research and you find a new case that was recently published that directly impacts this particular area of law that your client has retained you for representation, that you can then use that knowledge that you've acquired in subsequent representation. In fact, it benefits the profession, the administration of justice, as well as subsequent clients, for lawyers to continually be educated. My hope and my intention here was to draft something that just kind of plainly states that, yes, legal knowledge, legal research is not something that's subject to Rule 1.6's broad application. So maybe we can start there to see what are our feelings on this particular proposed comment.
Yeah, I'm going to call on Mark Enriquez. Mark, does that address your concerns from the last meeting?
It really does, and I think it does it really well. So thank you, Brian. I like it a lot.
Great, thank you, Mark.
Anybody else want to weigh in on this? Anybody have any wordsmithing or additions or modifications that they see right, immediately? I agree. It addresses that very singular issue that we discussed last time.
Evan, I agree with Mark. I think it's succinct and well written. I just actually the only thing I have about it is the fact I'm sad that we have to say that. I'm sad that we have to tell people that if you learned about damages in a conversion case, you can't talk about damages in a conversion case in a generic way. I think it's sad that we have to say that, but I think that the way Brian has put it here is, as I said, succinct and well written.
Yeah. Todd?
Yeah, I've got a couple thoughts. One is this is probably just technical. We use the word term. Should it be phrase? I think of a term as one word, and this is a phrase, obviously. And so that I think we can make that change throughout the proposal. The other question I had, a couple observations. I'm not sure what the first two sentences are designed to do. Because I had some time this morning, I looked at a couple things in the comments. I think the concepts and principles set forth in the first two sentences are pretty clearly set out in comment 2 to the rule. Comment 2 already addressed what is stated in the first two sentences. So it looks like this is obviously designed to add the last sentence addressing legal research. And I guess I had this question in terms of what we're talking about here. When we say legal research or other expansion, just the first phrase, legal research, are we talking about legal research independent of the issues in the matter that the lawyer is representing the client in? Or are we talking about something different? Here's my question. I thought we had said earlier, and I hope you can correct me, and I hope I'm wrong here. I'm glad to be wrong. I thought we had said earlier that the rule as currently drafted prohibits the lawyer from talking about things that were set out in the appellate opinions arising from this same case. For example, if there's an appeal to the Court of Appeals and there's a Supreme Court opinion on the issues at issue, that the rule as written would consider that to be something that the client could prohibit the lawyer from talking about. Did I misunderstand that, Brian, or not?
That was a concern that was brought up to us in response to the opinion. Because of how the opinion, the original opinion, how it was drafted, then we had in that flurry of comments, a number of folks that said, I acquired knowledge of an appellate decision during the representation. And are you telling me that I cannot subsequently use that knowledge? Or perhaps I participated in an appeal that resulted in a decision that would be beneficial to my subsequent clients. And are you saying I cannot use that because it's new information I acquired during the representation? I think the discussion was really that is one interpretation, and I think we all saw that as being something that would be very impractical and a bit ridiculous. And so that's where this comment was just trying to clarify that, because that was a recurring comment in the feedback we received on the opinion, wanted to be very clear that yes, 1.6 is incredibly broad, but that when we're talking about the knowledge that you gather with regards to a particular area of law, that is the sort of thing that is not encompassed by 1.6.
So does that mean, can you help me understand, I know we had some discussions on, are there any opinions on it in North Carolina or outside of North Carolina, which says whether or not lawyers are permitted to talk about matters and facts and claims that arise from appellate opinions in matters they're handling if the client says, I don't want you to talk about that?
I'm not aware of any opinion that specifically addresses that. Suzanne, you're our research guru, so I see she's shaking her head. Yeah, we have not seen anything like that.
Okay. And so what we're talking about here is simply if my client loses at trial and there's a whole appeal process and several issues coming out of that, me as the lawyer could talk about anything set forth in those opinions if the client even didn't want me to. Is that right?
I think so. I think that's I'm interpreting that, and I guess that was my thought process here in drafting.
And is that because the matter is then considered to be quote unquote in the public domain?
Yeah, I guess I think, well, and that's going to be getting to the next part where I think the next proposal works in kind of in congruence with this, because that's one of those things, like you have a specific client matter, their specific representation, their case, their facts, that becomes a part of the body of legal knowledge. And I guess maybe this is where I'm defining legal knowledge in my head. As it's the law, it's the body of law that upon which lawyers will rely in advising clients and making arguments, appellate or otherwise. So I think that when it becomes an opinion, and I also took this from the conversation at the October meeting, when it becomes an official opinion of the court, that type of thing it's almost like it transcends from client specific information that was confidential per 1.6 to now a part of the body of law that has potentially precedential value, for example, in North Carolina.
And so I can talk about anything in any appellate opinion in any CLE that I am presenting at, whether or not the client considers it embarrassing or detrimental. Is that where we had that? Is that how this would be interpreted?
I think so.
Okay.
Yes.
Yeah, it's broad. It's both legal knowledge and legal research is undefined and as broad as it can be, really.
Yeah, and I think this is where the legal research. I guess I should qualify my response that if we're talking about the opinion, what's in the opinion, I think that is legal knowledge and legal research. If we're talking about the lead up to the case, perhaps even the argument that you made and the strategy that you formed in making your appellate argument, I think that is something that is not legal knowledge and research. That's something that occurred, and perhaps information that you acquired or you acquired because you actually made the argument, that would be addressed by the next part or the next recommendation for amendment.
Let me ask you this. I'm fine on that legal knowledge piece. Can you tell me, I'm just trying to understand, since we're going to vote on this maybe, what is meant by other expansion of the lawyer's legal knowledge? I mean, is that defined in any way, or however the lawyer decides to define it?
Yeah, I think I guess then this is this is the wonderful part of looking at, kind of trying to peek into what the heck was Brian thinking when he drafted
Right, exactly. Exactly right.
The expansion of legal knowledge, I guess I take that as I guess becoming aware of whether you're talking about legal research, I'm looking into statutory law, case law, and just gaining a better understanding of a particular area of law. But as far as that expansion of legal knowledge, I take that to be that sometimes that expansion occurs not necessarily in the research context, that sometimes in the course of representing, in the course of pursuing a particular representation, you may find that a particular county enforces a policy as such. And it's not really a research matter. It's just that you are acquiring more information about how a particular ordinance is done, or a policy matter, a procedure that you learn about as you represent a client before a particular agency or whatever the case may be. And so that's where I think I tried to incorporate that experience as well as the focus on research.
Okay, thanks.
And Brian, with the legal acquired through legal research, it seems that might be broad enough to allow a lawyer to talk about his or her thinking as they progress through the legal research of the case, which touches on, I think, strategy and tactics, perhaps, as they. Is it, in your opinion, broad enough that a lawyer could do that?
I think so. I think if we're talking about a lawyer that's speaking about their understanding of the law and their perhaps evolution in understanding. I thought it was this way, and then I continued to do my research and discovered that perhaps this is a more effective argument if I am focusing on this particular statute, crime, whatever it is. I think where you end up with a line is starting to talk specifically about the client's case. The client was charged with this and this, and specifically identifying the client, because of course, as we still have in 1.6, particularly the comments or comment 4, that if you want to speak in hypotheticals in a way that doesn't really identify the client, that you can say, I had a client who was charged with X, Y, and Z, and as I learned more about the area of law and the development of that body of law over the past 5 years, it dawned on me this was going to be the best approach. But so yes, I think it is broad enough to talk about kind of the lawyer's just evolving knowledge and understanding of what's going on, including strategic decisions.
Hey, Evan, I don't want to hold up the discussion here. Now, one observation, Brian, that you can look at offline is the first lead-in sentence to comment 2 seems to be pretty unequivocal that you can't reveal anything absent consent. So consider whether we need to reconcile that with the new comment that you're considering adding.
Yes, I think, and that's, Todd, you're raising a great point that we're seeing kind of throughout, that there are, and kind of with the next proposal, it's a related thought. There are a number of spots where I think we need to iron out the potential for confusion.
Right.
And I think that's another one of them. The notion that like you're looking at, and I'll just, for anyone that wants to hear it, the first sentence of comment 2 to 1.6 says that a fundamental principle in the client-lawyer relationship is that in the absence of the client's informed consent, the lawyer must not reveal information acquired during the representation, period. And so that's the broad reach of 1.6 that I think this comment attempts to clarify, that it's perhaps not as broad as just everything, period. And so whether this sentiment, I think you had made the point earlier, Todd, kind of what's the purpose of the first 2 sentences here, because they are stated in other ways in the other parts of the comment. I thought the purpose that I had in writing that was to kind of reinforce the notion that confidentiality is important, that it is very broad and it's intentionally so, but that it's not supposed to incorporate this other aspect of knowledge that you will gather during the representation. Whether we should put this sentiment into, maybe amend comment 2 to include this particular sentiment, I think that's an option as well. I had not explored that as much. I just wrote it as a standalone to see if this is a principle that we agree on, and where exactly it fits might be a subsequent decision. But that's, I will continue to look at that and see if there's some other aspect that we might need to reconcile, as you pointed out.
Okay.
Thank you. It seems to me that this would be ideally located right after the first sentence comment.
Yeah, exactly. Yeah, that might be a good place for it, Evan.
Yeah.
Yeah, and that that instead of having it stand alone.
Right. Yeah. Then we can take a look at that. I see Ellen has her hand up. Oh, you're on mute, Ellen.
Sorry, just a quick comment on that, to sort of, one way to bridge that. I agree with Todd on the second sentence, the broad assurance. It seems unnecessary in this context. I like the way you're explaining why the phrase itself is so broad, but I given the conversation about what is included in legal research and what is included in the lawyer's legal knowledge, right? It may be that we need more on that in the comment and example. So that's one thing. And number 2, I don't think this, to Todd's point, I don't think the second sentence helps what your goal, Brian, of reminding folks about the importance of the uniqueness of this phrase.
Okay. No, that's great feedback. And I think as we're talking, I'm looking at comment 2 as well and thinking maybe that really is the spot where we really focus on this last sentence is what we're getting at. That's right. And perhaps that is the portion that we figure out a way to incorporate into comment 2 of Rule 1.6, including some examples. Trying to keep it brief. We're not trying to make the comment, a half a page or anything like that, but just to kind of, this would include X, Y, and Z, and go from there. So I will, I'll draft something up for the subcommittee's consideration that tries to incorporate this key provision here into comment 2 and see, which one do we like better.
I'll shut up now, Evan.
Pardon me.
I'll shut up now.
No, please don't, Todd. What you have to offer is very valuable. It seems to me that, like Ellen was saying, some of the precatory sentences in this new comment seem to repeat what is said in the rule and throughout the comments. So it may be it's repetitive in some respects. And if we distill this down to the last sentence that you've got highlighted there, Brian, and stick it at the right after the first sentence of comment 2, it gives a lot of clarity to what that first sentence means and what it doesn't mean.
I think that's great. All right.
Could I offer one quick thought? And Brian, you probably already had this, which is maybe we could put some examples that go to some of the comments that we got. You know what I mean? Like
Yeah,
directly
type
address.
those.
Yeah.
Sure.
I'm sure you already thought that, but just in case. Make
Thank
people
you.
feel heard.
Oh, they've been heard all right.
Oh, yeah, a lot. Yeah.
No, but that sort of stuff, is I appreciate hearing that because, yes, there's sometimes we on staff, we have these fleeting thoughts of, well, how else should we do this? But when you all make that suggestion, it means that we were actually on the right track. So that's good confirmation. Thank you for that.
All right. So what are we gonna do, Brian? You're gonna draft up something that fits into comment 2 and
Yes.
send it out.
That's what I'd like to do. I don't think we need to have a
Okay.
vote right now. I think we could just
All right.
take another crack at drafting something, but really try to merge it into comment 2 as it sounds like that's the most appropriate place.
Great.
All right.
Any other comments on this at this point? Okay, well, let's move into the meat of what we got going here.
All right. So I will tell you, this is rule 1.9, and I've added something here for your consideration. And I just added this today as I was thinking about it because I've been stewing over this. Suzanne and I have been talking about it, and then I talked with Alice and Carmen Bannon about this as I'm just trying to kind of get all those different perspectives about how do we advise on this rule? How do we enforce this rule? What's our understanding of interpreting and so forth, are teaching this. And we've got Ellen and Amy both teach professional responsibility courses here in North Carolina, in addition to Carmen and myself. And Carmen and I in particular, were talking about how sometimes silly it is to teach about generally known. So I'm kind of throwing you all a bit of a curveball here in throwing a potential amendment that would eliminate the term generally known into rule 1.9. But let me kind of give you a bit of background and really focusing on 1.9C2 to set that stage. So 1.9 is, and this is kind of, I guess, flowing from that conversation with the ethics committee in October. There was a lot of discussion that it seemed like we were all saying that, yes, the duty of confidentiality for current clients should remain. It is a strong thing. It's a necessary thing. It's a fundamental of our role as lawyers. But it seems like we all kind of see that when it's a former client, there is not necessarily an abandonment of the duty of confidentiality, but that perhaps there is a lesser concern about information, particularly information that was disclosed publicly during the course of the representation. And it certainly is one of those things that it sounded like from the conversations, as well as the feedback that we've received on the opinion, that the profession has treated former client information as special, or I should say public information about former clients, in a way that's probably not really in compliance with the rules. And yet, I think it was Brad Bannon that pointed out, if lawyers have been doing this for decades and there hasn't been client harm, we don't receive grievances from clients that say, my lawyer should never have talked about what was elicited in testimony during our public hearing. So that's where I started looking at Rule 1.9C2 as it currently stands. Rule 1.9C2 basically says that a lawyer or a law firm that was involved in the representation shall not thereafter reveal information relating to the representation except as these rules would permit or require with respect to a client. In essence, 1.9C2 just kind of confirms that even when you're dealing with a former client, Rule 1.6, very broad definition and required duty of confidentiality still applies to the former client. Based upon the conversation that came out in the ethics committee meeting, I drafted what you see here as underlined amended language that would permit a lawyer to disclose information that is contained in the official public record, was disclosed at a public record hearing, was disclosed at a public hearing, or was otherwise publicly disseminated, unless the information would likely be embarrassing or detrimental to the client if disclosed. The thought process behind this proposed amendment was, I guess, as far as I know, we've talked in this subcommittee before about, well, what exactly is the public record? How do we define that? And I think that's one of those things where, you know, we can get into some I guess, debates about what actually is the public record. I told Suzanne, well, it's any official record that's been made available to the public. Isn't that what public record is? We can just define it using its own terms. But nevertheless, we use this term, for example, in Rule 3.6, trial publicity. We've used this term before, I guess is what I'm saying. We have a statement under 3.6 that, you know, lawyers can't make extrajudicial statements that are going to have an impact on the proceeding, but a lawyer can talk about stuff that's in the public record, just kind of a blanket, you know, this part is okay as far as an exception that's being made to the general rule that you shouldn't talk about stuff that could impact the proceeding. But if it's in the public record, it's okay. So using that as kind of well, if we've done it in 3.6 successfully, maybe we can do that here with former clients, as seems to be the indicator, the takeaway from our conversation in October, as well as the feedback we received. I drafted this language that essentially, you know, again, it confirms, 1.9C2 confirms lawyers need to keep stuff confidential even after the termination of the relationship, except a lawyer can disclose this information, even if it would be technically covered by 1.6, because 1.6 is so broad, if that information is in the official public record, if it's disclosed at a public hearing, or it's otherwise publicly disseminated. But we have that little catch-all at the end that requires a lawyer to stop before just publicly disclosing, before running his or her mouth on whatever they want to do at a CLE, a podcast, or what have you, to stop and think, is my talking about this information likely to be detrimental or embarrassing to the client? And that thought process is hopefully supposed to give, another aspect of analysis for the lawyer that's about to engage in some sort of public discussion about a former client's information that is available, accessible to all members of the public already. And I go on, you can see in the proposal, there was a comment that I had drafted up that basically says that, you know, that confirms whether something is likely to be embarrassing or detrimental to a client if disclosed must be determined before the lawyer actually engages in the disclosure, and that the lawyer should elevate a client's interest over the lawyer's own interest in making that disclosure and really determining whether or not it's embarrassing or detrimental to the client. I had two kind of alternative ending sentences there. And after discussing this today, I've kind of concluded that I think the last sentence is the better one. It's the more clear sentence for guiding lawyers. And so the comment would end with, when it is unclear whether a lawyer's disclosure pursuant to this new amended rule, 1.9C2, would be embarrassing or detrimental to the client, a lawyer should consult with the client about the potential disclosure and the resulting impact thereof. It's not a shall, it's a should. But nevertheless, it sends the message that if something is unclear, a lawyer should reach out to the client and have a conversation before going off and speaking at that podcast. So I'm going to stop there before getting into my thought process of using similar language in 1.9C1, which deals with use of information. But like I said, I'll stop there. Maybe let's talk about what you think here.
Hey, Brian, just for my edification, I apologize, I'm getting old and can't remember. Did we discuss last time that as the rule is currently written and interpreted, at least in North Carolina and some other states, that Rule 1.6 would prohibit what you are now suggesting we add to C2.
Yes.
And so can you tell me how many, roughly, I'll hold you to it.
Sure.
Is North Carolina going to be out there on its own if we adopt what you're suggesting here?
No, we will not be on our own. The other states, if my memory is correct, I believe there are 10 other states that have some variation in their confidentiality rule that essentially allows for this type of disclosure, but they use different terms. Some use the public record or exempt from 1.6 entirely, information that's in the public record. Some use the term generally known, and things of that nature. But for the most part, most jurisdictions have a version of 1.6 similar to what we have right now and don't have any exceptions for public record information. As an aside, I'll tell you that this matter, they're in the process of planning for the ABA's Conference on Professional Responsibility that's coming up in the spring. And Alice, our own Alice Mine, is the leader on creating that program. And she had asked me for topics, and I suggested this one. She wasn't sure the response that she was going to get, but everybody on the planning committee loved this because they started realizing, yeah, how we interpret 1.6 is different than what it says. And I think we need to have a discussion about that. So I think I'm kind of curious if maybe this is going to start a wave of other jurisdictions examining 1.6 and how we carry it out. But again, to your point, Todd, there are other jurisdictions that allow this. We would not be on our own, but we would be in what is now the minority of jurisdictions that do allow dissemination or disclosure of public information.
All right, I'll give you my thoughts, Evan, and I'll be quiet.
No, don't be quiet.
I believe, well, I'm concerned, I'm concerned that this amendment might basically render much of 1.6's current prohibitions meaningless in terms of the client's say-so with respect to his or her information that a lawyer acquires during the representation. I remain concerned about what's official versus unofficial public record. I don't recall using the phrase official public record before. I thought we just used public records. I'm concerned about how do we distinguish between what's official versus what is not official, and what's otherwise publicly disseminated. How do you determine that? And I'm thinking about this too, as I continue to remind you guys that I'm thinking about this from the standpoint of not only being on this subcommittee, but also how the grievance committee would enforce such a grievance. And then the last point is I'm concerned that this latter part of the sentence, the unless part, basically lets the lawyer, not the client, make the total determination as to what would or not be embarrassing or detrimental to the client if disclosed. As I read it, this is the lawyer's sole determination, not having to necessarily confer with the client. I know you've got the comment down below, and I'm concerned about your pointing out the word should versus shall, because I believe should is simply something that's discretionary that the lawyer can or cannot follow, as opposed to shall. So those are my thoughts on that sentence there.
Sure. And if I can address some of the thoughts as far as what I was intending, and perhaps this will help us determine if different language should be used. I was intending this, of course, since this is under 1.9, this only applies to former clients.
Right.
So this only applies to after the representation has been terminated. 1.6 stands for current clients. And certainly it's limited to that information that is in the public record or was otherwise, that basically other folks other than the client or the lawyer during the course of the representation would be aware of, would be privy to. And I guess that's kind of this was the discussion that I had with Carmen this morning, as we talked about the ongoing duty that we have to former clients, that it's not exactly really a strong duty of loyalty the way that we have a duty of loyalty to our current clients. that we have a duty to keep confidential that which has been provided to us. But I guess that there is, it seems like a kind of a recognition of when something is available in the public, even during the course of the representation, it's been made public, that to put that restraint or that restriction on the lawyer from subsequently discussing that which is, I guess, potentially already being discussed by others. It kind of, I guess, maybe recognizes that perhaps the duty of confidentiality does not need to apply to that. And I think to the point that some folks had recognized in the ethics meeting, that I think clients would be surprised to find out that a lawyer is not allowed to talk about the testimony that just occurred in their stand or on the stand in their trial. Subsequent to the representation. I also want to give some background on the notion of official public record and where that came from. I spoke at a CLE with the School of Government sometime in October, and it was with a bunch of folks that were employees of different state agencies and the General Assembly and so forth. And as I was introducing this issue and kind of giving them an update on where we were and just kind of picking apart what we were talking about in the opinion, somebody offered the thought that, we actually had this issue at the General Assembly a couple of years ago. There was a statute, and the statute is 120-132. The statute, essentially, as it was previously written, was very broad and prohibited all legislative employees from speaking about anything that occurs in the course that they acquire, any information they acquire during the course of their employment with the General Assembly. And the person said that they realized that although it was never carried out that way, that statute technically prohibited legislative staff from, upon hearing the results of a vote in a public hearing or a public setting, from stepping outside of the chambers. And when somebody says, "Hey, what was the result of that vote?" that statute technically prohibited them from saying, "This is what just happened." And so they brought that to the attention of I guess the powers that be, their bosses, and they drafted up a new statute. And the new statute here, I'm not sure how quickly, I don't want to mess up anything too much by stopping sharing screens and sharing different ones. But 120-132B says that a present or former legislative employee may disclose information acquired under subsection A of this section. Subsection A basically gives the parameters when stuff is supposed to be confidential. So you can disclose information under that subsection that would be reflected in the official public record or was otherwise publicly disseminated. So that was the source of some of the language that I chose there, and recognizing that they had a very similar situation and resolved it with that kind of gave me the inspiration to give it a try here.
Okay.
And Todd, I think speaking to your point there, I'm not sure that this would necessarily gut 1.6. It sort of complies with the language in 3.6 that permits a lawyer to speak about matters in the public record on trial publicity stuff. But I think 1.6 is kind of the not really a preamble, but it's the overarching duty of a lawyer to understand the confidentiality of information, and does apply to current clients. To me, this squares with, it refines 1.6, but also squares with 3.6. That permits the lawyer to do exactly this with current clients.
Okay. Does C2, Brian, does C2 as written, when it says except as these rules would permit or require, does that, in your view, import rule 1.6 into this rule as well?
Yes, I think that essentially if information, like as it stands right now, and as it would continue to stand, that essentially this says that when you're dealing with a former client's information, 1.6 still applies, including its exceptions. So if there, for whatever reason, there's some one of the exceptions that's triggered under 1.6 that would permit disclosure to the extent reasonably necessary, then yeah, a lawyer could disclose information or reveal information. This additional language just kind of, I guess, carves out or authorizes a lawyer to talk about the information that's in the public record or has been publicly disseminated. But I've always interpreted 1.9C2 as really kind of a recitation of the duty of confidentiality that we see in 1.6, how that applies not just to current clients, but to former
Sure.
clients as well.
Yeah, I just want 1.6 and whatever change we make to 1.9 here to be reconciled as we discussed before, to be consistent, Evan, is all I'm suggesting.
Yes, completely agree.
So Brian, talk about why you use the word official public record as opposed to public record.
I don't think that word is material to what I'm proposing, but I use that because that's what we see in the statutory language that I just referenced. That I felt if it was something that the General Assembly was, they thought that it was appropriate to call the official public record, that perhaps we could find safety in numbers by calling it the official public record. But if it's going to cause problems as far as official or unofficial, then I have no problem jettisoning that that term.
David has a
David
question.
Starr has his hand raised.
Yeah.
David?
Hey, thanks. And thanks for inviting me to your meeting. It's a fascinating issue. On the issue of public record or official public record or otherwise publicly disseminated, I like the language. I will note that when I think about client information, sometimes I think about trade secrets. And under both the federal trade secret law and the state trade secret law, they use slightly different language. They use, and I think I'm reading here, not being generally known or readily ascertainable through proper means by the public. So you might consider that language, but I like what you have.
Great, thank you, David.
Hey, Ellen, yeah, you're up, but yeah, because remember we talked about generally known and public record. And so I figured you're going to speak on that.
Yeah, well, and I like this. I think this is really good work, Brian. I've said why I think this is a good idea, and I won't repeat that. I think this fits, and it fits with the way lawyers are behaving today. I do have one kind of, it may seem like a nitpicky question, and I think you can get me around it, Brian, but I'm thinking about the or otherwise publicly disseminated, right? So I understand public hearing and public record, and I'm indifferent as to the official language, although I do think we want to take care with what we choose there based on what other statutes and other laws say. But in terms of or otherwise publicly disseminated, so, I grew up in a town of 3,000 people, and being publicly disseminated in the Benson Review, right, would be, now let's assume we haven't had a public hearing, right? But if it's publicly disseminated in the Benson Review, but then I go on CNN and talk about it, I'm not saying I'm uncomfortable with that, but that would be a question I would have were I reading this outside of this conversation.
Sure. I think it's a fantastic question. This was the publicly disseminated, I guess clearly it's a broad sort of catch-all. And I see this as a bit of a I don't want to say a tip of the cap to the generally known thing or a substitution of generally known, but I guess this is the notion that, if something is not disseminated, is not in the public record, it's not testified to at the public hearing, but it becomes publicly disseminated via the newspaper or something like that. Is a lawyer allowed to say at a subsequent CLE podcast, whatever they're doing, they're talking about it, to say, well, then the New York Times ended up running this story about my client. I guess that sort of thing, I understand that it perhaps is a bit squishy, but I prefer this to generally known, because I think it is, and this is kind of that enforcement concept that I was talking with Carmen about, and to that end, Todd, for whatever it's worth, Carmen and I were talking about how do we enforce that. She liked this better than what we currently have. She felt like she would be able to enforce this. But yeah, the publicly disseminated thing is just, I guess, that notion that there are things that do get out there. And is a lawyer supposed to not speak about that which everyone else is already speaking about, whether it's due to a newspaper article, a WREL investigation report? I know, we could be talking about, well, what are we saying? Social media as well. Everybody in this group in the neighborhood is talking about such and such. One of your clients' particular cases, is that something that you cannot acknowledge or provide some sort of recitation? I think it's a great conversation to have. I personally wrote it because I think that putting that restriction on the lawyer in that regard, if it's not something that would be embarrassing or detrimental, didn't seem to serve a client, like a purpose for protecting the client. But
I completely, like, from a policy standpoint, I completely agree with that. I wonder though, if thinking about it, not just in terms of publicly disseminated, but, known in the community or known locally, that kind of thing. I think some other jurisdictions have done that. I agree with getting away from generally known. And I agree that if it's been publicly disseminated from a policy reason, the lawyer should be able to talk about it. But I think we could massage that language if it bothers others.
Yeah, Jack, you got your hand up.
Thanks, Evan. Yes, no, so I agree with what y'all are saying on that point. A quick point, something that Todd brought up that I think it's made me really think here. Todd mentioned enforceability aspects on the grievance committee. And as I look at the language here, a lawyer may XYZ unless the information wouldn't be embarrassing. And I think we have beaten to death the fact that we all agree that terms that are so relative and subjective as embarrassing, what's embarrassing to one versus the next, would it be helpful to, and maybe this is as much to Todd as anyone else, would it be helpful rather than having language would say a lawyer may X unless Y, where Y is something that can't really be defined, and which would throw Todd and the grievance guys and gals into whatever. Would it be easier to say something, a lawyer may X, however, should avoid A, B, and C? In other words, without any qualifying language, the unless language throws us, I think, into the morass of subjectivity that would be extremely difficult. And I didn't see that. And thank you, Todd, for bringing that up. I didn't think about it from those terms because I'm not on the grievance committee, thank God. And so, but as soon as Todd said that, and I reread the language, I thought, how would we enforce that? But anyway, I'll shut up. Thank you, Todd, for bringing that up.
No, I think it's a fantastic question as well. And that's where I think when we talk about subjectivity in our rules, unfortunately, we have a fair amount of it already, like in rule 4.4, as I'm thinking, that lawyers are prohibited from doing something that has no substantial purpose other than to embarrass, delay, or burden a third person. It's what does that mean?
No doubt. Yeah.
But and I'm not trying to say that because we have kind of squishy language elsewhere that we should put squishy language here. I think that I get my thought process in drafting that and using the term unless was to kind of put on the lawyer that essentially it's that this disclosure is, I guess you could say, it is still prohibited if it is likely to be embarrassing or detrimental. Now, that would require, for enforcement purposes, should this ever come up, it would require, for enforcement purposes, the Office of Counsel to establish that a reasonable lawyer would have seen that disclosure of this particular information, sensitive information about the client that was a part of testimony at a hearing or what have you, that it was likely to be embarrassing or likely to be detrimental to the client, including looking at the after effects of the lawyer's public speech about that particular information. It is something that I don't claim would be a clean case in any way, but it does give something to the Office of Counsel as opposed to just a blanket. You can talk about it. It gives the Office of Counsel something to look at. And again, it would be a reasonableness standard that we'd have to approach with the DHC. But also the other kind of purpose in drafting that was to essentially kind of insert a moment for lawyers to pump the brakes, so to speak, before they go and start talking about something, to say, well, wait a second, is this embarrassing or is this detrimental to my client? I need to think about that before I actually go and say what I intend to say at a CLE or other public setting. And then from that, looking at the comment that was drafted to encourage lawyers, and it is encourage. I don't know if we want to include a shall, because I think, as we've talked about before, that was kind of getting into the whole veto aspect of the client, that should a lawyer or shall a lawyer consult with the client, because if that is a requirement, that might not always be possible, whether the client is unavailable, you can't locate the person, perhaps they've passed away, and it's a case that you had 10 years ago, and now you can't talk about that, which is in the public record, about your experience in the case and the lessons that you learned from that case, because you have to consult with the client. And I guess I took from the conversation in October, as well as prior subcommittee meetings, that overall we're kind of uncomfortable with the veto notion that a client exclusively possesses. And I have grown more comfortable with the notion that, yes, and this is to your point, Todd, earlier, that subjectively speaking, a lawyer could reach that conclusion. If it's a reasonable conclusion, this isn't embarrassing or detrimental, they can go ahead and speak. They're not required to consult with the client, but that perhaps that's different or not necessary when you're talking about a former client's publicly available information.
Yeah, I see the purpose of that phrase as putting lawyers on notice that they need to consider that. It's a notice clause.
Thank you.
Hey, one quick question. Is in the proposed comment about embarrassing or detrimental, you got the phrase "while not required." If we deleted that, would the sentence still have the same force?
Yes, and that's I was actually going to propose that we delete that sentence altogether, Todd. You can see on my screen here, because
I see it.
You saw I had bracketed language.
Yeah.
For whatever reason, I kind of feel like the last sentence, the bracketed sentence, is probably the better one. But if you all disagree, we can talk about that too.
Well, let's finish up talking about the possible changes in C1 and C2 before we get into the comment.
Okay. Would you like me to talk about C1 and just kind of give a thought process here?
Sure, let's do.
Sure. So C1 is the provision, again, 1.9 dealing with former clients, saying that a lawyer shall not, or a lawyer who's formerly represented a client, shall not thereafter use information to the representation to the disadvantage of the former client, except as the rules permit, or when the information has become generally known. That's the language that we currently have. That is the language that I think folks have mistakenly interpreted to be kind of if it's public, then I can talk about it. And that's incorrect. 1.9 C1 really, we talked about 1.9 C2 being kind of a recitation of 1.6, a carrying over the duty of confidentiality into the former client context. 1.9 C1 I've interpreted to be a carryover of the duty that we have for current clients under 1.8B. 1.8B says that a lawyer shall not use information to the disadvantage of the client. That's in the current client scenario. 1.9 C1 basically says, hey, that principle that we announced in 1.8, it still applies to the former client, except that you can use information to the disadvantage of your former client if the information you're using has become generally known. In terms of enforcement and advising that we've experienced here at the bar as the staff on the bar, it generally known, what is and is not generally known is rather difficult to define. We have a comment under 1.9 that talks about generally known, and the notion that, you know, it could be something that maybe is not in the public record, or just that it may not be in the public record, but it's known by the community that interacts with this information. Or to the contrary, just because something is in the public record does not mean that it's generally known. And it leaves us in kind of a, frankly, I feel like a weird state. And I don't know, Amy and Ellen, if you've had the same experience in trying to teach this to law students, and law students say, what the heck am I supposed to do with generally known? I can't tell if it's narrow or if it's broad. And so to eliminate that, since we're here already, that's where I was looking at that, and also seeing that we would suddenly have different standards. You can use information if it's not generally known, and you can reveal information unless it's public record. I thought maybe it would be just a bit more consistent and helpful to lawyers to use a similar phrase and eliminate the term generally known. So the proposal would be to have that same clause, you know, that you cannot use information with respect to the disadvantage of a former client unless the information is reflected in the official public record, was disclosed at a public hearing, or was otherwise publicly disseminated. I think that really kind of encompasses what previously was interpreted as generally known, but I think sets more clear parameters as to what information you can and cannot use to the potential disadvantage of your client. So that was the thought process there.
Hey, Eben and Brian, is it possible for the phrase official public record to encompass otherwise publicly disseminated?
I think that,
Ellen?
I think, yeah, I think public record would be too narrow because that's what we're talking about. Publicly disseminated stuff can be something that didn't actually make it into a public record, but everybody knows it because it was reported, or, you know, or whatever means that it was sent out and made public.
Plus, Todd, we have district courts that are not courts of record, at least on the criminal side. So, but they are public hearings.
Thanks.
So, how does everybody feel? I think I feel some consensus here, Todd. You know, do I feel you warming up to this?
Some of it. Yeah, I mean, I like the changes. I mean, I as I said, I don't particularly like the shoulds throughout this, because I think it's hard to enforce a should. But I guess we don't, correct me, Brian, I said I'm getting old. We don't enforce the comments anyway, just the rule.
That's correct.
So I guess when I look at it that way, Eben, you know, if the should is in the rule, I mean, should is in the comment and not the rule, that can be sort of advisory. So I'm warming up to this. I mean, Brian's done some good work, and the committee certainly has. So this is good.
I don't mean to call them out, but I'm kind of curious what our our professional responsibility professors think about this. And I'm looking at you, Amy and Ellen.
Ellen, you want to go? You want me to go?
Go ahead.
Well, and I'm a holdout on this. Todd and I were keeping it strong on a lot of this. I like it. I will admit, I really like the change to generally known, just because it is really hard to teach that every year. And they're like, well, what does that mean? And I'm like, no one knows. So I like that. I think it narrows it in a way that makes me a little more comfortable about the client coming first. Like I think the comments in these changes make me feel better about what I think should be the core of this, which is we got to be able to do our jobs and help the bar, but the client should come first. I think this is a nice balance.
Amy, do you have any issues with the fact that this just applies to former clients?
No, I like that. I'm gonna be honest. All
right. Ellen?
I like it too. You know, I might in a perfect world, I may have made it slightly broader, but I think this is a good place. I think this is a very good place. I think it'll be easier to teach. I think it'll be easier to help students understand. I think it'll be easier for students to understand it. And I don't know if it's more importantly or not, I think lawyers will have an easier time understanding it.
Brian, is this so the comment where you put these are rules of reason, which is my very favorite thing to be in the comments. I know we're not supposed to be getting too far ahead.
Yeah.
It's like something I live by and trying to explain. Is that the first time that's in the North Carolina comments? Do you know?
No, the rules of reason. Right. Well, no, that, I mean, it's in the scope, but we have, I
Yeah.
believe, well, you know, in any other comment, I don't know.
I don't
feel
think
like
it is.
there might
So
yeah, that's tough.
I'm sorry, that was a really hard question, but I just have always really liked it. I know it's in the scope, but to see it in a comment, I think is just really helpful for, I think maybe an enforcement
Yeah,
aspect of this and advising client aspect of it. So.
right. So if I can, I'll just kind of quickly address this one, that this is a comment primarily drafted by Suzanne. And I've tweaked it a little bit, as you see on your screen. It's slightly different than the version that was sent out to you earlier this morning, to be a bit more direct, just to say that, you know, yes, the rules of professional conduct are rules of reason, and to kind of, you know, instead of directly quoting the dictionary definition, I've just kind of said that, you know, to reveal is to make public something that was secret or hidden. I think the dictionary definition actually used the term generally known, and I felt like that was just going to be confusing. So kind of, I guess, paraphrase to some extent. But really noting that yes, revealing something is making public that which was secret or hidden, and a lawyer cannot reveal that which has already been revealed via public disclosure. That essentially you're not revealing anything anymore because it's already been revealed. And that's what justifies or supports this new kind of exception that we have. It occurred to me that perhaps that could have been an approach under the original opinion, that, you know, that a lawyer does not reveal that which has already been revealed and therefore is not prohibited from speaking about it. But I think that would have potentially led to a bunch of more questions and some confusion on exactly what the parameters are. So I still think this is the more appropriate way to go. But this comment is just really trying to kind of explain the thought process here, and support the overall notion that we're getting at.
Do we need to add C1 in there too? C1 and C2?
Yes, I think so. And that's where I'd probably want to massage that again. I'm clearly going to be redrafting some of this stuff here and sending you all a new version that I think incorporates all that we've discussed today. But yeah, I think that was really referencing the revealing of information and not necessarily the use of information, which, for the record, I do think are two separate things and should remain separated. In C1 and C2, we're talking about two very different actions, I guess, with regards to information. But I'll massage that to see if that kind of melds well in the comment.
Well, one question on that rule of reason paragraph, and the next to last line there, you use the phrase widely disseminated. I mean, should that be publicly disseminated so that we're consistent with everything else?
Yes, and that's where I think the version that's on your screen, I eliminated that term, widely disseminated.
Oh, I hope I'm looking at the right thing. I thought I was looking at what Suzanne distributed this morning.
Yes, and that's
you got
right.
some changes.
Yes, I made some. I'm making it more difficult, Todd, because I was tinkering with it even after Suzanne sent it out, and I realized, wait a second, we need to change this just a little bit. So I apologize.
It seems like you're only confusing me. Everybody else seems to be on track, quite frankly. Thank you. That's good. Thank you.
All right. Well, that's all I have to say. I don't know if conversation is concluded. I know we've reached over an hour now, Evan. So maybe the best thing would be for me to take all that we've talked about, put this back into a workable format so you all can see the extent of the changes that we've discussed, and send out the revised version to the subcommittee. Potentially, if we have some sort of consensus that maybe we have another meeting before the January meeting, even if it's just a brief meeting, perhaps just after the holidays, to talk about, yes, I think we can present this to the ethics committee.
Yeah, I would love to do that. And I don't know, maybe we're close enough to consensus that your tweaks, we can send it out and folks can email back that they're voting for it without, really having another formal Zoom meeting.
Right.
So I think we're close. We're very close. Jack?
Oh, no, I was just giving a thumbs up. Yes.
Okay. All right. All right. Any other comments before we close this up? This is awesome, guys. So this really, I think, solves the conundrum that we've had with cognitive dissonance on what actually is happening in the practice and what the rule actually prohibits.
Yeah.
So, and I'm comfortable with this being with former clients as well. I just like the way now 1.6 folds into 1.9 and folds into 3.6. It seems to square them all pretty much together. So, all right. If there's no further discussion, we'll wait for Brian and Suzanne to send out the revisions and we'll comment on them. Thank you all very, very much. It's great.
Thanks.